State statutes governing the establishment of a condominium complex generally require a party to file a declaration of condominium, or master deed. This declaration serves as a contract between unit owners and the Condominium Owners Association by spelling out the parties' mutual rights and obligations. Conversely, unit owners and the Owners Association may contractually agree to bylaws, which are a form of private lawmaking where the parties establish rules for how the condominium will operate. But what if the Owners Association wishes to prohibit owners from renting units, and this prohibition isn't included in the declaration? May the association later include this type of use restriction in its bylaws? The Wisconsin Supreme Court considered this question in Apple Valley Gardens Association v. MacHutta. In the late 1970s, Stephen and Gloria MacHutta developed the Apple Valley Gardens condominium complex in Wisconsin. Stephen filed a declaration of condominium stating that any leases or rental agreements wouldn't relieve owners from their obligations to pay common expenses or other obligations imposed on all unit owners. Nearly a decade later, a dispute arose between the MacHuttas and the Condominiums Owners Association over the MacHuttas renting their units. The parties then entered into a settlement agreement that limited Stephen, his family members, and his businesses to 4 rental units. But the agreement didn't give Gloria the right to rent her condominium units. In 2002, the association amended its bylaws to prohibit owners from renting their units. Further, the association amended its bylaws to require written consent from the board of directors for any renewal or extension of any lease or rental agreement that was in existence. 2 years later, one of Gloria's tenants vacated her unit, and Gloria submitted a new lease application, which the board refused. Nevertheless, Gloria leased the unit to a new tenant. Subsequently, the association sued the MacHuttas in state circuit court for a declaratory judgment that the bylaws amendment was enforceable. The MacHuttas moved for judgment on the pleadings, which the court denied. The parties then both moved for summary judgment, and the court entered judgment for the association. The MacHuttas appealed to the Court of Appeals, which affirmed. The MacHuttas then petitioned the Wisconsin Supreme Court for review.